Take a deep breath. Tonight, we delve into the exhilarating realm of Rule 4, where font sizes and margin widths dictate the fate of justice. Prepare yourself for a journey through the meticulous art of document formatting, where every indent and line space carries the weight of the law. No need to take notes. You won't remember this anyway. Now that you're comfortable, let's begin. Rule 4. Court Documents. Document Standards. 4.01. A document in writing in a proceeding shall meet the following standards. 1. In the case of a document in paper format, 1. The text shall be printed, typed, written, or reproduced legibly with double spaces between the lines and a margin of approximately 40 millimeters on the left-hand side. 2. The characters used shall be of at least 12 point or 10 pitch size. 3. Good quality white paper or good quality near white recycled paper, 216 millimeters by 279 millimeters shall be used. And 4. Text may appear on one side or on both sides of the paper. 2. In the case of a document that is filed or submitted in electronic format using software authorized by the Ministry of the Attorney General for the purpose, the document must meet 1. The requirements set out in subparagraph 1, 1 and 2, and 2. Any requirements specified by the authorized software. Electronic signatures. 4.0111. In this rule, electronic signature means electronic information that a person creates or adopts in order to sign a document and that is in, attached to, or associated with the document. Electronic signatures permitted. 2. A document that may or must be signed by the court, a registrar, a judge, or an officer under these rules may be signed with an electronic signature. Contents. General heading. 4.02.1. Every document in a proceeding shall have a heading in accordance with Form 4A actions or 4B applications that sets out A. The name of the court and the court file number, and B. The title of the proceeding in accordance with Rule 14.06 action or application, but in a document other than an originating process, pleading, record, order, or report, where there are more than two parties to the proceeding, a short title showing the names of the first party on each side, followed by the words "and others," may be used. 1.1. Clause 1b does not apply to documents in a proceeding under Rule 74, 74.1, or 75. Body of document. 2. Every document in a proceeding shall contain A. The title of the document, B. Its date, C. Where the document is filed by a party and not issued by a registrar, or as an originating process, the name, address, and telephone number of the lawyer filing the document, or where a party acts in person, his or her name, address for service, and telephone number, and D, where the document is issued by a registrar, the address of the court office in which the proceeding was commenced, or in the case of an application to the divisional court, the address of the court office in the place where the application is to be heard. Backsheet. 3. Every document in a proceeding shall have a backsheet in accordance with Form 4C that sets out A. The short title of the proceeding. B. The name of the court and the court file number. C. In the case of an affidavit, the deponent's name and the date when he or she swore it. D. The location of the court office in which the proceeding was commenced. E. The title of the document. F. If a lawyer is serving or filing the document, the lawyer's name, address, telephone number, email address, and law society membership number. G. If a party is acting in person, his or her name, address for service, telephone number, and email address if any, and H. If the document is to be served, the email address, if known, of the person on whom the document is to be served. Bilingual documents. 4.02.1. A pleading or any other document written in French that may be filed under Section 126 of the Courts of Justice Act may also include a version of all or part of the text written in English. Certified copies of court documents. 4.03. 1. The registrar shall provide a certified copy of a document that is in the court file to a person who is entitled to see the document under Section 137 of the Courts of Justice Act, if the person files a requisition, Form 4E, and pays the prescribed fee, if any. Certified copy in electronic format. 2. The registrar may provide a certified copy in electronic format of a document that is in the court file. Valid certification. 3. For the purposes of these rules, a copy of a document is validly certified under this rule if A. The copy bears the registrar's signature and the date of certification, and B. In the case of a copy that is provided in electronic format, the copy actually reproduces the information set out in the document, even if the way in which information is displayed in the document and in the copy differs. Printed version of electronic certified copy may be used. 4. If a certified copy of a document is provided by the registrar in electronic format, a requirement under these rules that a person provide a certified copy of a document to another person in paper format may be satisfied by printing the electronic certified copy by any means that produces the document in paper format and providing the printed version of the certified copy. Notice to be given in writing or electronically. 4.04.1. A notice required to be given by these rules shall be given A. In writing, or B. Electronically, if the use of electronic means is authorized. Issuing and filing documents. Issuing documents. 4.051. A document may be issued on personal attendance in the court office by the party seeking to issue it or by someone on the party's behalf, unless these rules provide otherwise. Electronic issuing. 1.1. Any document to be issued under these rules may be issued electronically. A. By the registrar dating, signing, and sealing with an electronic version of the seal of the court a copy of the document in electronic format. Or B. By use of the software authorized by the Ministry of the Attorney General for the purpose. Deemed issuing. 1.2. A document under Subrule 1.1 shall be deemed to have been issued by the Superior Court of Justice. Notice document issued. 1.3. After a document is issued electronically, notice that it was issued shall be sent to the party that had it issued. Place of filing. 2. The following requirements govern the place of filing of documents in proceedings unless the documents are filed in the course of a hearing or these rules provide otherwise. 1. All documents required to be filed in a proceeding shall be filed in the court office in which the proceeding was commenced, subject to paragraphs 2, 3, and 4. 2. If the proceeding has been transferred to another county in accordance with Rule 13.1.02, the documents shall be filed in the court office in the new county, subject to paragraph 3. 3. An affidavit, transcript, record, or factum to be used at a hearing shall be filed in the court office in the county where the hearing is to be held. 4. Documents relating to a motion to transfer a proceeding to another county under Rule 13.1.02 shall be filed in the court office of the county to which the transfer is sought, if Subrule 13.1.02 3.1 applies. Filing by leaving in court office or by mail. 4. Any document, other than one that is to be issued, may be filed by leaving it in the proper court office or mailing it to the proper court office, accompanied by the prescribed fee. Electronic filing. 4.1. If these rules permit or require a document to be filed electronically, the software authorized by the Ministry of the Attorney General for the purpose shall be used for filing. Confirmation of filing. 4.2. The electronic filing of a document in accordance with this rule shall be confirmed by way of a notice of accepted filing given through the authorized software. Date of filing where filed by mail. 5. Where a document is filed by mail, the date of the filing stamp of the court office on the document shall be deemed to be the date of its filing unless the court orders otherwise. Where document filed by mail not received. 6. Where a court office has no record of the receipt of a document alleged to have been filed by mail, the document shall be deemed not to have been filed unless the court orders otherwise. Date of electronic issuance. Filing. 7. A document that is issued or filed electronically is considered to have been issued or filed, as the case may be, on the date indicated on the document by the registrar or the authorized software. Issuance. Filing outside of business hours. 8. If a document is issued or filed electronically outside of regular business hours, the registrar or the authorized software shall indicate that the document was issued or filed, as the case may be, on the next day that is not a holiday. Requirement to keep original. 10. A person who electronically files a document that was originally signed, certified, or commissioned in paper format shall a. Retain the original document in paper format until the 30th day after the expiry of the period for an appeal in the proceeding, and b. Make the original document in paper format available for inspection and copying no later than 5 days after a request of the court or of any party to the proceeding to do so. Civil Claims Online Portal 4.05.1.1. Civil Claims Online Portal means the software authorized by the Ministry of the Attorney General for the purposes of this rule, and that is available on the Internet under the name Civil Claims Online Portal in English and Portail en ligne pour les actions civiles in French. Documents that may be filed through portal. 2. Subject to Subrule 3, the following documents may be filed electronically through the Civil Claims Online Portal. 1. A Statement of Claim, Form 14A, 14B, or 14D. 2. A Notice of Action, Form 14C. 2.1. A Statement of Defense, Form 18A, including one that includes a counterclaim against parties to the main action only, Form 27A, or a cross-claim, Form 28A. 2.2. A Notice of Intent to Defend, Form 18B. 2.3. A Notice of Discontinuance, Form 23A, and a Consent to Discontinuance, filed for the purposes of Clause 23.01(1)(c). 2.4. A Defense to Counterclaim, Form 27C. 2.5. A Defense to Cross-Claim, Form 28C. 2.6. Form 29A, Third-Party Claim, including with respect to a fourth or subsequent party claim, or claim by a defendant to a counterclaim or cross-claim. 2.7. Form 29B, Third-Party Defense, including with respect to a defense by a fourth or subsequent party. 2.8. A Jury Notice, Form 47A. 3. An affidavit for the purposes of Subrule 7.022. 4. A requisition or written statement under Clause 5.1a of Ontario Regulation 53.1 Bilingual Proceedings made under the Courts of Justice Act. 5.1. A certificate of action under Section 36 of the Construction Act, Form 14 under that Act. 6. Any consent or court order required to be filed together with a document referred to in the subrule. 7. Proof of service under Rule 16.09 or in Form 17A, 17B, or 17C of a document that is filed electronically under this rule. Agreement. 3. Subrule 2 does not apply unless the party filing the document through the Civil Claims online portal agrees to its terms of use, including providing an email address at which he or she agrees to accept documents from the court electronically. Inconsistencies. 5. In the event of an inconsistency between information provided in a document filed electronically by a person through the Civil Claims online portal and information provided by the person through the Civil Claims online portal that is not in the electronically filed document. A. The information in the electronically filed document prevails, except with respect to the county specified by the person for the purposes of Rule 13.1, where the information provided through the Civil Claims online portal prevails. And B. The registrar may request from the person written clarification in the manner specified by the registrar respecting the inconsistency, and the person shall promptly provide it. Documents that may be issued through portal. 7. The following documents may be issued electronically through the Civil Claims online portal. 1. A statement of claim in Form 14A or 14B. 2. A notice of action, Form 14C. 3. A third, fourth, or subsequent party claim, Form 29A. 4. A certificate of action under Section 36 of the Construction Act, Form 14 under that Act. Civil Submissions Online Portal 4.05.2. 1. In this rule, Civil Submissions Online Portal means a software authorized by the Ministry of the Attorney General for the purposes of this rule, and that is available on the Internet under the name Civil Submissions Online Portal in English and Portail en ligne pour soumettre des documents dans les actions civiles in French. Documents that may be filed. 2. Any document that may or must be filed under these rules, other than a document listed under Subrule 4.05.1.2, or that is filed for the purposes of Rule 60.07, may be filed electronically by submitting the document through the Civil Submissions Online Portal if the Civil Submissions Online Portal provides for the electronic filing of the document. Registrar's acceptance required. 3. A document submitted for filing through the Civil Submissions Online Portal is filed only if it's accepted by the registrar. Confirmation. 4. If the registrar accepts the document for filing, the registrar shall send confirmation of the filing by email. Filing date. 5. A document filed under Subrule 3 is considered to have been filed on the day indicated in the confirmation sent by the registrar. Documents that may be issued. 6. Any document that may or must be issued under these rules, other than a document listed under Subrule 4.05.17, or that is issued for the purpose of Rule 60.07 may be issued electronically by submitting the document through the Civil Submissions online portal if the Civil Submissions online portal provides for the electronic issuance of the document. Registrar's acceptance required. 7. A document submitted for issuance through the Civil Submissions online portal will be issued only if it is accepted by the registrar. Confirmation. 8. If the registrar accepts the document for issuance, the registrar shall issue the document and send confirmation of the issuance by email together with the issued document. Issuance date. 9. A document issued by the registrar under Subrule 8 is considered to have been issued on the day indicated in the confirmation sent by the registrar. Filing, issuance of other documents. 10. Despite Subrules 2 and 6, a document listed under Subrule 4.05.1, 2, or 7 may be filed or issued, as the case may be, electronically by using the Civil Submissions online portal in accordance with this rule, if a prescribed fee is not required to be paid for the filing or issuance of the document. If clarification needed. 11. The registrar may request from a person written clarification with respect to a document that is submitted for filing or issuance, and the person shall provide the clarification in the manner specified by the registrar. No filing or issuance without acceptance. 12. For greater certainty, a document that is not accepted by the registrar for filing or issuance is not considered to have been filed or issued, as the case may be. Requirement to agree to terms of use. 13. Despite Subrules 2 and 6, a document may not be filed or issued electronically by using the Civil Submissions online portal unless the person requesting the filing or issuance agrees to its terms of use, including providing an email address at which the person agrees to accept documents from the court electronically. Non-application of certain subrules. 14. Subrules 4.05, 4.2, 7, and 8 do not apply with respect to a document filed or issued electronically by using the Civil Submissions online portal. Case Center 4.05.3.1. In this rule, Case Center means the software authorized by the Ministry of the Attorney General for the purposes of this rule and that is available on the Internet under the name Case Center. Application 2. Unless the court directs otherwise, this rule applies to all or part of any hearing, pretrial conference, or case conference held in the Superior Court of Justice or the Divisional Court. Requirement to use Case Center. 3. Every party participating in the hearing or conference shall provide the following documents to the court by uploading them to Case Center in accordance with this rule. 1. A copy of every document filed with the court by the party in respect of the hearing or conference. 2. Subject to Subrule 5, a copy of any other document in the court file on which the party intends to rely at the hearing or conference that has not already been uploaded to Case Center by another party. 3. Unless the court directs otherwise, and subject to Rule 3.1, a compendium that meets the requirements of Subrule 7. 3.1. A compendium is not required to be provided with respect to a conference or the hearing of an unopposed motion or motion to consent unless the court directs otherwise. Deadline. 4. Subject to Subrule 5, the documents listed in Subrule 3 must be uploaded to Case Center by the following deadline. 1. In the case of the hearing of a motion or application where the party is required to give the registrar a confirmation of motion, Form 37B, or confirmation of application, Form 38B, the deadline is 2 p.m., 3 days before the hearing date, unless the court orders otherwise. 2. In any other case, the deadline is 5 days before the date of the hearing or conference, unless the court orders otherwise. Transcripts. 5. A transcript for use at a trial shall not be uploaded to Case Center until a party refers to the transcript at trial and files a copy of it in accordance with Subrule 34.18(4), and for greater certainty, that subrule also applies with respect to the copy uploaded to Case Center. Document requirements. 6. A document that is uploaded to Case Center must meet the following requirements. 1. The document must be uploaded in the following formats. 1. A copy of a draft order or factum must be uploaded in both portable document format, PDF, and Word format. 2. Any other document must be uploaded only in portable document format, PDF, or, if appropriate, in Excel format, except that an exhibit may be uploaded in any format accepted by Case Center. 2. The document name, as uploaded to Case Center, must indicate 1. The document type. 2. The type of party uploading the document. 3. The name of the party uploading the document. And 4. The date on which the document was created or signed in the format DD MMM YYYY, e.g. 12 Jan 2021. 3. A copy of a factum that is uploaded to Case Center must meet the requirements that are specified in Subrule 4.06(1)(3) for an electronically filed factum, even if the factum was originally filed in paper format. 4. A copy of a book of authorities that is uploaded to Case Center must meet the requirements that are specified in Subrule 4.06.1(5) for an electronically filed book of authorities, even if the book of authorities was originally filed in paper format. Compendium requirements. 7. For the purposes of paragraph 3 of Subrule 3, the compendium must meet the following requirements. 1. The compendium must include a table of contents listing only those authorities, transcripts, previous orders, and other documents on which the party intends to rely during the hearing or conference, as applicable, hyperlinked in accordance with paragraph 3. 2. The compendium must include the relevant excerpts of every document listed in the table of contents with a separate section for each document. 3. Each document listed in the table of contents must be hyperlinked. 1. To the section of the compendium containing the excerpt or excerpts of the document, and 2. If the document is published on a website referred to in Subrule 7.1, to the published document, or, if possible, the relevant provision or portion of the published document. 7.1. Subparagraph 3 of Subrule 7 applies with respect to the Canadian Legal Information Institute website, CanLII, eLaws, or another Government of Ontario website, the Federal Justice Laws website, and any other similar website that is accessible without charge or subscription. Document must be identical to document in court file. 8. The party shall ensure that every document that the party uploads to Case Center is identical to that document as contained in the court file, subject to any modifications required by this rule or the court. Requirement to keep original. 9. A party who uploads a document to Case Center shall A. Retain the original document until the 30th day after the expiry of the period for an appeal in the proceeding, and B. On the request of the court, the registrar or another party make the original document available to the court, registrar, or party for inspection no later than 5 days after the request is made. Document in court file prevails. 10. In the event of an inconsistency between information provided in a document in the court file and information provided in a document uploaded to Case Center, the information in the document in the court file prevails. Does not amount to filing or service. 11. For greater certainty, uploading documents to Case Center does not amount to the filing or service of those documents under these rules. Affidavits. Format. 4.06.1. An affidavit used in a proceeding shall A. Be in Form 4D, B. Be expressed in the first person, C. State the full name of the deponent, and if the deponent is a party or a lawyer, officer, director, member, or employee of a party, shall state that fact. D. Be divided into paragraphs, numbered consecutively, with each paragraph being confined, as far as possible, to a particular statement of fact. And E. Be signed by the deponent and sworn or affirmed in accordance with the Commissioners for Taking Affidavits Act. Contents. 2. An affidavit shall be confined to the statement of facts within the personal knowledge of the deponent or to other evidence that the deponent could give if testifying as a witness in court, except where these rules provide otherwise. Exhibits. 3. An exhibit that is referred to in an affidavit shall be marked as such by the person taking the affidavit, and where the exhibit A is referred to as being attached to the affidavit, it shall be attached to and filed with the affidavit. B is referred to as being produced and shown to the deponent, it shall not be attached to the affidavit or filed with it, but shall be left with the registrar for the use of the court, and on the disposition of the matter in respect of which the affidavit was filed, the exhibit shall be returned to the lawyer or party who filed the affidavit, unless the court orders otherwise. And C is a document. A copy shall be served with the affidavit unless it is impractical to do so. By two or more deponents. 4. Where an affidavit is made by two or more deponents, there shall be a separate jurat for each deponent unless all deponents make the affidavit before the same person at the same time, in which case one jurat containing the words sworn or affirmed by the above named deponents may be used. For corporation. 5. Where these rules require an affidavit to be made by a party, and the party is a corporation, the affidavit may be made for the corporation by an officer, director, or employee of the corporation. For a partnership. 6. Where these rules require an affidavit to be made by a party, and the party is a partnership, the affidavit may be made for the partnership by a member or employee of the partnership. By an illiterate or blind person. 7. Where it appears to a person taking an affidavit that the deponent is illiterate or blind, the person shall certify in the jurat that the affidavit was read in his or her presence to the deponent, that the deponent appeared to understand it, and that the deponent signed the affidavit or placed his or her mark on it in the presence of the person taking the affidavit. By a person who does not understand the language. 8. Where it appears to a person taking an affidavit that the deponent does not understand the language used in the affidavit, the person shall certify in the jurat that the affidavit was interpreted to the deponent in the person's presence by a named interpreter who took an oath or made an affirmation before him or her to interpret the affidavit correctly. Alterations. 9. Any interlineation, erasure, or other alteration in an affidavit shall be initialed by the person taking the affidavit, and unless so initialed, the affidavit shall not be used without leave of the presiding judge or officer. Factums. 4.06. 1. 1. A factum that is required to be filed by these rules shall consist of a concise argument stating the facts and law relied on by the party filing the factum. Citations. 2. Each citation to an authority in a factum must include a reference to the relevant paragraph, provision, or page number of the authority. 2.1. A factum shall include a statement signed by the party's lawyer or on the lawyer's behalf by someone the lawyer has specifically authorized, certifying that the person signing the statement is satisfied as to the authenticity of every authority cited in the factum. 2.2. An authority that is published on a government website or otherwise by a government printer on the Canadian Legal Information Institute website, CanLII, on a court's website, or by a commercial publisher of court decisions is presumed to be authentic for the purposes of Subrule 2.1, absence evidence to the contrary, if filed electronically. 3. A factum that is filed electronically must meet the following requirements. 1. The factum must include bookmarks, as appropriate, for each section. 2. each citation to an authority that is published on a website referred to in subrule 4.05.3 7.1 must be hyperlinked to the published authority or, if possible, to the relevant provision or portion of the published authority, when Book of Authorities is also required. 4. Except in a proceeding in the Court of Appeal, if a factum is filed electronically and contains one or more cited authorities that cannot be hyperlinked in accordance with Subrule 3, or is filed in paper format, a Book of Authorities that meets the requirements of Subrule 5 shall be served and filed together with the factum. Contents. 5. Unless the court orders otherwise, a Book of Authorities shall contain the following information and documents. 1. A table of contents listing each authority cited in the factum. 2. If the Book of Authorities is being filed in electronic format, 1. For each cited authority that is published on a website referred to in subrule 4.053 7.1, a hyperlink from the table of contents to that document, and 2. For each cited authority that is not published on a website referred to in subrule 4.05.3 7.1, a copy of that authority with a hyperlink to it from the table of contents. 3. If the Book of Authorities is being filed in paper format, a copy of each cited authority. Other requirements. 6. Any other requirements in these rules respecting factums or books of authorities apply in addition to the requirements of this rule unless the rules provide otherwise. Binding of documents. Records. 4.07. 1. Records for motions, applications, trials, and appeals shall have a light blue backsheet. 1.1. Front covers of records for motions shall be A. Green in the case of a responding party's motion record. B. Orange in the case of a record for a motion under Clause 134(4) B of the Courts of Justice Act, motion to receive further evidence. And C. White in any other case. Transcripts. 2. Transcripts of evidence for use on a motion or application or at trial shall have a light gray backsheet. Appeal book and compendium. 3. An appeal book and compendium shall be bound front and back in buff covers. Transcripts on appeal. 4. Transcripts of evidence for use in an appeal shall be bound front and back in red covers, except where the transcript forms part of the appeal book and compendium or record, and where there is more than one volume of transcripts, the volume shall be clearly numbered. Factums and books of authorities. 5. Factums and books of authorities shall be bound front and back. A. In white covers, if filed by an applicant, moving party, or appellant, or B. In green covers, if filed by a respondent or responding party. Cover stock. 6. Backsheets and covers shall be of 176 grams per square meter cover stock. Electronic documents. 7. This rule does not apply to a document that is filed electronically in accordance with these rules or uploaded to Case Center under Rule 4.05.3. However, if the same document is filed or provided to the court in paper format, this rule applies to the paper version of the document. Requisition 4.08. Where a party is entitled to require the registrar to carry out a duty under these rules, the party may do so by filing a requisition, Form 4E, and paying the prescribed fee, if any. Transcripts. Paper size 4.09.1. Evidence shall be transcribed on paper 216 millimeters by 279 millimeters in size, with a margin of 25 millimeters wide on the left side, delimited by a vertical line. Heading 2. The name of the court, or in the case of an examiner, the examiner's name, title, and location shall be stated on a single line no more than 15 millimeters from the top of the first page. Standards 3. The text shall be typed on 32 lines, numbered in the margin at every fifth line. 4. Headings, such as swearing of a witness, direct examination, and cross-examination, shall be capitalized and separated from the preceding text by the space of a numbered line and the number of the lines of text on the page may be reduced by 1 for each heading that appears on the page. 5. Every question shall commence on a new line and shall begin with the designation Q, followed within 10 millimeters by the question. 6. Every answer shall commence on a new line and shall begin with the designation A, followed within 10 millimeters by the answer. 7. The first line of a question or answer shall be indented 35 millimeters from the margin and shall be 130 millimeters in length. 8. In a transcript of evidence taken in court, every line of a question or answer, other than the first line, shall begin at the margin and shall be 165 millimeters in length. 9. In a transcript of evidence taken out of court, every line of a question or answer, other than the first line, shall begin 15 millimeters from the margin and shall be 150 millimeters in length, and questions shall be numbered consecutively by means of a number placed in the 15 millimeters to the right of the margin. 10. Lines of text, other than questions and answers, shall be indented 35 millimeters from the margin and shall be 130 millimeters in length. 11. Every transcript of evidence taken in court or out of court shall have A. A cover page setting out 1. The court. 2. The title of the proceeding. 3. The nature of the hearing or examination. 4. The place and date of the hearing or examination. 5. The name of the presiding judge or officer. And 6. The names of the lawyers representing the parties. And B. A table of contents setting out 1. The name of each witness with the page number at which the examination, cross-examination, and re-examination of the witness commence. 2. The page number at which the charge to the jury, the objections to the charge, and the recharge commence. 3. The page number at which the reasons for judgment commence. 4. a list of the exhibits with the page number at which they were made exhibits. And 5. At the foot of the page, the date the transcript was ordered, the date it was completed, and the date the parties were notified of its completion. Transcripts to be provided in electronic format. 12. Unless the court orders otherwise, a transcript that is served, filed, sent, or otherwise provided under these rules shall be served, filed, sent, or provided in electronic format except in proceedings in the Court of Appeal. Same. Transition. 13. Subrule 12 applies to proceedings commenced on or after the day on which subsection 10.2 of Ontario Regulation 689/20 came into force. Transmission of documents. 4.10. 1. Where documents filed with the court or exhibits in the custody of an officer are required for use at another location, the registrar shall send them to the registrar at the other location on a party's requisition on payment of the prescribed fee. 2. Documents or exhibits that have been filed at or sent to a location other than where the proceeding was commenced for a hearing at that location shall be sent by the registrar after the completion of the hearing to the registrar at the court office where the proceeding was commenced. Notice of Constitutional Question. 4.11. The Notice of Constitutional Question referred to in Section 109 of the Courts of Justice Act shall be in Form 4F. Emailing of documents, communications by registrar. Documents. 4.12. 1. Any document that the court or registrar may or must send, give, or otherwise provide to a person under these rules may be sent to the person in electronic format by email to A. The email address most recently indicated for the person in the applicable court file, if any, or B. In the case of a lawyer whose email address is not indicated in the court file, the email address for the lawyer as published on the Law Society of Ontario's website. Communications. 2. Any communication that the court or registrar may or must send to a person in connection with the proceeding under these rules may be sent to the person in electronic format by email to A. The email address most recently indicated for the person in the applicable court file, if any, or B. In the case of a lawyer whose email address is not indicated in the court file, the email address for the lawyer as published on the Law Society of Ontario's website. Application. 3. This rule applies despite anything to the contrary in these rules. Rule 4.1. Duty of expert. Duty of expert. 4.1.011. It is the duty of every expert engaged by or on behalf of a party to provide evidence in relation to a proceeding under these rules. A. To provide opinion evidence that is fair, objective, and non-partisan. B. To provide opinion evidence that is related only to matters that are within the expert's area of expertise. And C, to provide such additional assistance as the court may reasonably require to determine a matter in issue. Duty prevails. 2. The duty in subrule 1 prevails over any obligation owed by the expert to the party by whom or on whose behalf he or she is engaged. All right, that's it for now. Not that anyone's still awake to hear it. I'll stay up reading so you don't have to. Good night.